Thank you very much.
All right, thank you, Mr.
Thank you very much, moderator. Thank you.
All right, thank you, Doctor. Appreciate it. All right, to begin our conversation, ladies and gentlemen, I would like to invite our speakers to share their perspective on an issue that has been on the front burner of discourse for some time. So, gentlemen, to both of you, many ADR practitioners have complained that arbitration has in some way become so concerned with looking like a court that it is gradually forgetting why it was created as an alternative to the court in the first place. So in your experience, would you think that arbitration is gradually grinding to a point of excessive formalism? And if yes, would you say that this is the biggest threat that is currently facing arbitration in Nigeria and Africa as a whole? So I think you can start with Dr. Madume, please, sir.
Okay, so all right, so thank you very much, moderator. I should start by thanking the entire management of NCCDRC for the opportunity and the privilege to be a part of this webinar and to share my thoughts on this very important subject. Now, I think the point to start from is to recognize, from the outset, that arbitration is a justice system. It's a justice system also that is adversarial. And because of that, certain methods and certain procedures are required. But also, we must recognize that arbitration has peculiarities that sets it apart from other dispute resolution mechanisms. For instance, arbitration was, evolved not as a formal process in the sense that we have in the courts. It evolved as a mechanism by business people, commercial-minded people, to resolve their disputes. However, because arbitration system, there is the fundamental requirement of fairness. And that requirement of fairness is reflected in the obligation of independence and impartiality by the arbitrators. And over the years also, both in law and in practice, you see a reflection of that fundamental requirement of fairness. For instance, Section 1.1 of our Arbitration Constitution Act clarifies to us the objective of arbitration. It says that arbitration is a process that allows a neutral third party to deliver justice to parties in a way that is fair, without undue cost and undue expense. So fairness is very critical. However, in implementing that requirement, arbitration and arbitration practitioners are required not to dilute the fundamental advantages of arbitration, which is the advantage of flexibility, advantage of simplicity, and advantage of parties can fundamentally choose whatever they want to choose, as long as it conforms with the law. The only obligation a tribunal has, or arbitration has, in arbitration is to maintain the fundamental requirements of fairness, which is called equal opportunity, giving parties equal, full opportunity of presenting their case. But you see in practice, and I agree with that sentiment. You see in practice a lot of practitioners now adopt or replicate what happens in court in arbitration, and that's a threat. For an arbitration practitioner, who lives by this process, I see that as a threat. I see it, and that highlights the importance of this kind of webinar, where we need to bring to our awareness once again what we should be doing as arbitrators. So I agree entirely that there is a threat of formalism in arbitration, but it is not insurmountable. And I take this as my opening remarks. As we go on, I will unveil a lot more what my thoughts are on the subject. Thank you.
So we should do another link to send during the course of the...
All right, thank you so much, Dr. Madume, for the insightful opening remark. I'm happy that you've stated that you agree that it is indeed a threat, but it is not insurmountable. Yes, so I agree with that absolutely with you, and I'm sure we agree. I would like to invite Mr. Paul at this point to also share his thoughts.
Yes, let me also start by thanking the NCCDRC for inviting. Now, yes, I believe that there are some truth in the concern, but I don't think arbitration has lost its way entirely.
You know that
What I
page
see
you can edit it
is
for
a
you.
gradual,
Oh, from that
maybe
page, just
sometimes unconscious migration of courtroom culture into arbitration. Can you hear me? Yes. Arbitration was designed flexible, efficient, and party driven.
What's the other
Yet,
thing?
in many cases, we see some excessive
Hearing another
procedural application, prolonged, excessive document production, repeated adjournments, hearing almost
can put
becoming
it
like
in Chinese, blah, 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 blah,
courtroom
blah.
trials. The danger is not in
Thank
procedure
you.
themselves.
So that
Procedures are actually
yes,
necessary for fairness. The danger is when
thank
procedure
you.
becomes an end in itself
ensuring
rather than
somehow
to achieve
having
justice. In my
beauty,
view,
beauty.
one of the greatest threats facing arbitration in Nigeria is not external interference, maybe from courts, but
Operations of
gradual decline into courtroom trials. If
the
arbitration
NCCDRC.
comes slow, expensive, or as technical as litigation, parties will now begin to ask, why are we choosing arbitration after all? So I think the challenge before us is therefore not to eliminate formalities, but to preserve it proportionally. We must
It's post
ensure
effects.
that arbitration remain recognized
Thank you.
different from
Okay,
litigation
just
while maintaining fairness and due process. Thank you.
Thank you so very much, Mr. Paul. And
We had participants
you have
include
mentioned
interest, enjoyment of
that
decision. It is not that I was not maintaining as much as
what
masculine.
we are
The
witnessing is
ability and
rather
application of
more like an into
conditions
migration. And I really, really agree with you on that. And I think I will just stay with you at this point to discuss one of the tendencies and habits
Wait,
that
how many
has
people am I now sending
gradually
this thing to?
migrated and snowballed into arbitration,
this
and we are witnessing today,
easy,
and that is
Yes, you
adjournments.
will have to use my own.
easy.
Now, we agree that adjournments are sometimes necessary to ensure fairness.
Easy.
But in your opinion, when do they become a threat, to the credibility of
Pushing
arbitration? And should
how many
arbitrators
people
be
now on
more
what?
It's
assertive
100 now.
in
It's
rejecting
100
Don't
already.
even know
adjournment
persons.
requests
As we
that,
dey
in their opinion, are intended to merely
More.
delay
Let me send it
proceedings?
sharp sharp.
And for me, I see it more as the difference lies in distinguishing what is necessary from what is convenient. Adjournments are legitimate when they are genuinely requested to
Okay.
protect fairness. For example, if there's a medical emergency or there's a significant procedural issue or circumstances generally beyond the party's control. Adjournments, however, become problematic when they are sought principally for convenience or advantage or for undue delay. At that point, we begin to undermine confidence
What
in
would I
the
now
process.
subject? What subject?
I think if arbitrators are more
What
assertive,
can I use as subject?
it should be more arbitrators should be more assertive.
what's the word?
Fairness should not
So
be mistaken
should
for
be
convenience. So
Please check your.
indeed, one of the responsibilities of the arbitrator is to protect the integrity and efficiency of the procedure. An arbitrator who grants every adjournment request may inadvertently be rewarding delay
intellectual
and
meeting capacity.
prejudicing
It's
the other
copyrighting
party
at the same time.
that is
I'm just make
generally
it part
that
of.
is ready to proceed. So the
How do
key
you
is
forget now?
to act when refusing or allowing an adjournment. Will he deny fair hearing? If the answer is no,
Sha, sha, sha.
deny fair hearing, then the arbitrator must be confident to allow the matter to proceed and not grant an adjournment. Thank you.
All right, thank you so much, sir. So I'm really happy that you had mentioned that there's a need for arbitrators to, as a matter of practice, distinguish between what is necessary from what is convenient and what looks like a tactical advantage. Thank you so much for that. And we immediately go back to Dr. Madumere. Right, Doctor, I want us to look at what looks like a concern from arbitrators, from the angle of arbitrators. Now, do you think that arbitrators have become too concerned about protecting awards from challenges and enforcement risk? So much so that they have now created unnecessary rigid procedures in arbitration.
Okay, so thank you very much, Mr. Edem. Before I go on to answering your question, let me just, make a rebuttal to the views expressed by Mr. Abolemem, a while ago. The core point when it comes to issues about requests for adjournment is for an arbitrator to draw a distinction between what are the parameters. At what point should I, as an arbitrator, draw a line between my obligation to ensure fair hearing and allowing strategic advantage to any party to obstruct the other party? There is something they call guerrilla tactics in international arbitration. Most practitioners deployed guerrilla tactics to either get an advantage or to frustrate the hearing of that arbitration. So for a tribunal must be fully aware of its obligation to conducting the process in a way that is fair, efficient, and effective. Now, to your question, Ms. Edim, as to whether, at what point, whether arbitrators have become concerned with regards to challenges, my straight answer to you is that any arbitrator that is unduly concerned about right of challenge is actually showing lack of understanding of what he needs to do as an arbitrator. It is a manifestation of, allow me to use this word, I'm not being condescending, but it is a
It's not showing Zoom
manifestation
What do you want?
LTN is so horrible. It's not Blanco.
Yes, back.
Hearing.
There are 4 people.
It seems we lost Dr. Madumere.
Not done.
He's still here with us.
My apologies. I'm on fiber, and yet I don't understand it.
So
My
sorry, sir.
apologies. My
So
apologies.
sorry.
Please. Yes. So, as I was saying before, I dropped off. Every arbitrator must understand that he is sitting over that dispute as the Supreme Court over the facts. No court can substitute your ruling on facts with their own rulings. So on the facts of the matter, you are the Supreme Court of on that dispute. So you should be able to exhibit confidence that inspires the way you conduct that inspires the way you
seems we lost Doctor again.
It's like the village at work today.
they will not have access to you, sir.
So I think I've answered. Let me allow Mr. Boleme, to have his bite on the cherry. Thank you, sir.
Mr. Paul, I don't know if you have anything to add on that.
Yes, I just want to say that
Because have become too concerned about protecting their awards from challenges and enforcement risk, thereby creating unnecessary procedures to serve as a
this is what I would call due process paranoia. When arbitrators have an exaggerated fear that any robust case management outside the procedure that has been set will lead to their work being set aside. So I think the consequence is that such arbitrators will now start prioritizing process over efficiency and would lead to over-cautiousness, passive behavior, where is their case, let them, if they want adjournment, give them, if they want to delay a final. So I think arbitration practitioners should shy away from that, and because it's going to defeat the whole essence of arbitration, which is which one of them is because speed, efficiency, and cost. So if you have this what I've referred as due process paranoia, arbitration is gradually losing its value. Any trade arbitrators should not have that fear of award being set aside as a ground to be overtly cautious. Thank you. Like Dr. Madmiri said, the arbitral panel is like a Supreme Court on issues of facts. No court can challenge it. So why be fear? Do your job and face it squarely. Thank you very much.
Exactly. So from what both of you have said, we can all agree, just like Dr. Madumari has said, that it is a lack of understanding of the strength of a panel that would make an arbitrator be concerned about concern itself about challenges to its award. And I agree completely with you, gentlemen. So, Mr. Paul, I think we'll just stay with you. At this point, one of the major criticisms of arbitration today is that parties increasingly deploy litigation style delay. So the tactics of delaying litigation, that litigation style, they import it into arbitration, just like you had noted earlier. So I would like for arbitrators that are here, and even for practitioners that are on this webinar, I would like you to, single out some of those common points of delay tactics that you have observed, even as it comes an arbitration process, and as an arbitrator on the side of the bench, and how significant is a problem to temporary arbitration.
Okay, delay tactics is one of the most significant practical challenge in arbitration. Common tactics include requests for adjournments, unnecessary requests for adjournments, excessive document production. I once did an arbitration where one of the parties had documents in excess of over 1,000 pages, like 2 reams of papers, as part of their including exhibits. There were too many, and some of them were not even necessary. So excessive document production requests, challenge to arbitrators, maybe challenge them at strategic moments, maybe not at the beginning, repeated objection to jurisdiction, last minute applications to bring in more evidence, to bring additional witness, maybe unnecessary lengthy pleadings. I've also observed what I would call procedural saturation, where the party will flood the proceedings with motion, correspondences, that in the hope of exhausting the other party. or slowing down the process. These tactics are damaging because arbitration itself relies heavily on cooperation and procedural discipline. Unlike court, arbitration is built around party autonomy. So unfortunately, when this autonomy is sometimes abused, the problem becomes very, you can't even, it's underestimated. The problem that it brings, or it brings delay, increase in cost, it erodes confidence, and the arbitration is now losing its value, which one of the principal advantages of arbitration is cost and efficiency and speed. So these delay tactics, which Dr. referred to as singular tactics, reduces the confidence that people have in arbitration.
All right, thank you so much, sir. I don't know if Dr. Madume would like to add something to that, because there are arbitrators here. There are intending and aspiring arbitrators here, so that they would get to know when they see these litigation style delay tactics being deployed whenever they are on a panel or whenever they are on the other side as a counsel. I don't know if you can point this out and your experience, share with us what you have gotten to see and realize in the practice of arbitration over the years, sir.
Okay, so thank you very much. I endorse completely what Mr. Bolime has said. I mean, he has given a very practical illustration of those instances. But let me also add my voice to what he has said. On the 5th of June, I sat over an international arbitration panel. I'm the presiding. My co-arbitrator is a professor from Kenya. The other arbitrator is a senior lawyer from Rwanda. 2 days before that date, the respondent lawyer, they call them senior counsel in their country, just like SN here. He dropped before the tribunal 993-page document. 990. Please, can you please mute yourself, Thomas, please?
Mute,
can you please mute your device? Thank you, sir. So 2 days before the hearing date, he dropped 993-page bundle of documents without index of how to navigate around those, that bundle. I just got a mail from my co-arbitrator from Rwanda that, chair, I think we must adjourn. I said, no, we cannot adjourn. The professor from Kenya also said, no. I said, no, we cannot adjourn. I'm going to ask them to please give us an index of how to navigate around. I wrote to them, and they ignored me. On the hearing date, we sat. In fact, that was I joined that hearing from Lagos because it was a virtual hearing. I knew what they wanted to do. What they wanted to do was just to truncate the date that we had agreed, and it took us time to come to that date. The claimant is an English company, and they had concluded that the end of the trial on the 21st of May. Defense was supposed to open on that date. The senior counsel said no, that they needed a clear date of their own. And we obliged them. And they were not trying to truncate that date. I said, no, we will not do that. So I insisted, and on that date, I was shocked. I said, and they have just one witness. I said, are you able to put your witness, on the witness seat now? He said, yes. Can you please go ahead and do that? We did, and it turned out that most of the documents they packaged to put together were all irrelevant documents, mostly irrelevant documents. And the trial went ahead. We concluded hearing that day, and then gave dates to, to file, their written submissions. The point I want to highlight from that story is that as an arbitrator, you must be on top of your craft. You must be a step ahead of the lawyers on both sides. Lawyers will always be lawyers, whether in Nigeria or anywhere else. They will always be lawyers. Of course, not many. People might be a lot more civil in the way they operate, but then the objective is the same. Objective is to get an advantage, procedural advantage. So you as a tribunal, you must be up to your craft to ensure that you stop them on their tracks. Number two is also what that Mr. Boleme mentioned. Lawyers use it a lot in international arbitration. They can front load 30 bundles of documents just to overwhelm the other side and to intimidate them. You should see through that tactics, and not allow yourself to be intimidated. Again, another thing they also do in international arbitration is to appoint a lawyer that has a relationship with one of the tribunal members just to cause a conflict, and then ask the tribunal, ask the man involved, to retire or to resign. That is why, as a tribunal, once you are constituted, one of the first things you must do is to make disclosures and then obtain assurances from parties that they do not have any jurisdictional objection, of any sort on the members of the tribunal, because lawyers can do a lot of things, to gain advantage. So those are my thoughts, sir. Thank you.
All right, thank you so much, sir. I'm glad that we all agree that.
Is it my network again, or is it from end?
I think it's from his
Yes,
end
thank
this
you, sir.
time.
Is it?
All right, so sorry. I don't know if you can hear me now. I was yanked off by the network. All right. I think my is working now, sir. All right. I was trying to say this particular subject is that lawyers will always remain lawyers, and then it is the duty of arbitrators to remain on the top of their craft, know what they should do at every point in time, and not giving to litigation gimmicks of lawyers. So, Dr. Madumeri, I think we'll just stay with you now and immediately subject. There are some people that claim that the blame should not go to arbitrators alone. They say counsel also have no matter how much we say it, we begin it so that lawyers on this web would hear, and maybe the more they hear it, there would be a rejig in their mind. They will unlearn and relearn, because people have said that counsel play a major part, in how arbitration is gradually turning into courtroom litigation. So do you agree? I would say you agree, but then do you think that counsel sometimes contribute to the over proceduralization by expecting arbitration to mirror litigation? And if yes, what is that one mindset shift? What's that one mindset shift that you would advise that every arbitrator, every practitioner, you should take away from this discourse and adopt it immediately?
Okay, sir. So thank you very much, Mr. Edim. I agree that lawyers will sometimes, adopt methods, that appear to bring in a lot of litigation, attitudes into arbitration. But then that again takes us back to the expertise of the arbitral panel. I have seen instances. I was in Lagos, I think last two Mondays. I was in a panel, in an arbitral panel, and you saw lawyers filing motion supported by an affidavit with a written address for an application as simple as extension of time. And in my heart, I'm like, hold on a minute. What are we doing here? Are we in court? This is something that between lawyers on both sides, they can actually thrash out by themselves and inform me as a tribunal. Why would you file a notice for application for extension of time? You are not before a court. You are before an arbitrary tribunal, and our methods are very, very, less formal in terms of those mechanics that you find in the courts. So it's for you as a tribunal, to actually put your feet down and let parties know how it should be done. I mean, I cannot be in sitting as a tribunal without lawyers, even the language of lawyers. Yes, my lord. I said, you are not. I'm not your lord. No, with all due respect, don't address me as my lord, Mr. Arbitrator, Honorable Arbitrator. That is how it is done internationally, and that also causes embarrassment for us, even as a country. And with all due respect, I don't want to mention anybody's name. Sometimes when you read the record of proceedings of huge arbitral matters outside this country, where our very senior lawyers are cancelled, you'll be embarrassed. And once you do that at an international tribunal, they will just know that this one is not